When deciding the best entity to operate the consulting firm, there are a number of non-tax and tax factors that should be considered. The non-tax factors include who are the owners of the company. It's important to understand if, for example, the owners are not U.S. citizens. If that's the case, then the company cannot be formed as an S corporation. It's also important to consider where the business will be located. Where the business will be located will likely be the best place to form that consulting company. Sometimes businesses hear that it's best to form an entity in a particular jurisdiction, such as Delaware or Nevada. But if the company is located in a place other than those states and they're consulting, then those states may not offer the most favorable tax or administrative characteristics as the jurisdiction in which the business is actually located. Another big consideration is the financing of the company. If the company is likely to get outside investment and that outside investor wants a particular type of business entity formed, then you'll need to understand that and form that particular entity. This is not as significant for a consulting company, which is likely to be self-financed and may get bank financing or other third-party financing that doesn't include venture investment. Other factors to consider include the ease of forming the company. With a limited liability company, it just takes filing articles of organization or certificate of organization with the state in order to form it. It's also important to consider how easy is it to manage or administer the particular business entity. With a corporation, there are a number of different formalities that need to be complied with in order to operate that company. These include having annual shareholder meetings, taking minutes, keeping certain corporate documents. These same formalities are not required of limited liability companies. The final non-tax factor that we'll discuss is whether the consultant will need to compensate employees with options. If the consulting company would like to issue options to any of its employees or any of its contractors, then it'll need to set up a C corporation to do so. There are two significant tax factors that need to be considered when deciding which entity to form. First, how will the profits from the company be distributed to the individual owners? If the individual owners see themselves working for the company and getting paid wages, then they need to seriously think about self-employment tax. If the consulting company sets up an S corporation, they may be able to avoid paying a certain portion of self-employment tax if they pay themselves in the form of distributions as opposed to wages. Whereas if an LLC is set up, the owners of the LLC who are actively involved in the LLC aren't able to avoid paying self-employment tax. Another issue is whether there will be losses from the company. If there are losses from the company, then the individual owners will want to be able to take those losses against their personal income. And the limited liability company and S corporation allow that to happen. When we were talking about the non-tax issues to consider when selecting a business entity, one of the factors was where is the business located? A lot of businesses have heard that setting up a company in Delaware or perhaps Nevada is the best place to operate the company. This isn't necessarily the case for a consulting company. It's often best to form the company in the actual state in which the company is located. And this is the case for a number of reasons. Setting up the company in another state may result in additional fees. For example, fees for outside counsel who can advise on different corporate issues. Another reason why it may be best not to form the company in another state is because this may not reduce the taxes that the company owes. For example, if a business is located in Michigan, but they want to set up in Delaware, they'll be required to pay Delaware franchise taxes. Another disadvantage is that if the business is located in a state outside of where the business is operating, that business is subject to the jurisdiction and service of process of that other jurisdiction. If there are any lawsuits that are filed against the business, they'd have to go to that other place in order to fight that lawsuit. And finally, there may be a difference in filing fees, reporting requirements, and other notice requirements in other states that make it challenging for that business to comply with all of those requirements of that other state. And the business would also have to qualify to do business in the particular state in which it's located. So then there are two sets of rules that the company needs to be aware of as they're operating their company. After the company is formed, it's important for the founders of the company to talk about how the equity in the company is going to be divided between the founders. For a consulting company, again, this may not likely be as relevant, but it's important to cover in case there is more than one founder in this consulting company. So it's important to decide equity splits early on in the operation of the company, again, to avoid any misunderstandings between the founders as to who owns what in the company. When you're deciding how the equity should be divided in the company, you must look at what has the previous contribution of the founder been, or the founders been, as well as what is the contribution of the founders to the company going forward. It has to be a holistic understanding of what each of the founders are going to contribute in terms of time and dedication to the company. Some of the particular questions that the founders should ask themselves when deciding how equity should be divided is, has that particular founder developed the idea or developed the intellectual property? If that's the case, then that founder should get a higher percentage of ownership in the company. Another important consideration is whether the founder contributed cash to the company. If that's the case, then the founder should get a higher percentage of ownership in the company. An owner should get a lower percentage interest in the company if that owner will be working part-time or less than the other owners that are involved in the company. Other considerations include whether a founder spent more time prior to incorporation on the company than other founders. If that's the case, the founder should receive a higher percentage interest in the company. If a founder is going to have more responsibility in the company going forward, then that founder should have a higher percentage ownership interest in the company. These are just a few examples to give you to think about as you're developing the ownership interest in the company. It's important to really look at your particular company and how the owners are actually working together to determine the most equitable splits in the company, because you don't want to divide things equally if that's not how owners are actually working together in the company.